Welcome to today's program titled Unlocking Opportunities, Navigating the New Era of U.S. Immigration. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification form will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Leon Rodriguez. Leon, please go ahead.
Thank you very much, and good afternoon, listeners. My name is Leon Rodriguez. I'm a partner at Seyfarth Shaw, and I am accompanied today by a tremendous panel to speak with you about the Notice of Proposed Rulemaking issued by U.S. Citizenship and Immigration Services entitled H-1B Modernization. We'll get into the details of this rule, but it is something that has a lot of potential impact for those employers who sponsor significant numbers of employees in the H-1B category. Again, my name is Leon Rodriguez. I'm a member of Seyfarth's Business Immigration Group. I'm also the former director of U.S. Citizenship and Immigration Services. I'm joined also by my partner, Masa Aliascari. She's in our Los Angeles office. She is the lead partner on several of our largest and most complex immigration portfolios. She has a particular concentration on mergers and acquisitions and companies that are engaged in that on a frequent basis. I'm also joined by my colleague, Steve Briard, who's out of our Boston office. So we do have a coast-to-coast thing going here. Steve represents and advises U.S. and multinational corporations on a variety of employment-related immigration and compliance matters, including non-immigrant visas and immigrant visas. And I am thrilled to welcome my good friend, former colleague, Randy Johnson, who is now a distinguished immigration scholar at Cornell Law School. Previously, he was a partner here at Seyfarth and joined us immediately after serving for a number of years as a vice president for government relations at the U.S. Chamber of Commerce. His group at Cornell recently issued a novel white paper proposing targeted immigration reforms, and Randy is also finalizing a paper on the rule of law and the I-9 employment verification procedures, which is quite good. Thanks for taking a break from academia, Randy, and joining us here today. So I want to start, before we go over our program snapshot, with just sort of a basic idea about today. There's good news and bad news. The good news is that some of the things that may not necessarily work for employers in this H-1B modernization rule aren't going to happen tomorrow. They're not going to happen next week. It's going to take a while before they happen. And they may not happen exactly as we are describing today. In fact, some of our discussion today will be about how we change those things that folks may not like. On the other hand, there are some important parts of this rule that address some burning issues in the world of employment-based immigration, and unfortunately, those may take some time too, unless they're approached in a different way by the Department of Homeland Security. So just wanted to share that. So anything that's too scary, there not be a panic about that. So our, can we go to the next slide with the program snapshot? We're going to talk a little bit about how we got here, where we are generally in the world of immigration. H-1B is not something you hear about in the news every evening, but this is sort of part of a larger immigration landscape out there. We're going to spend a lot of time talking about this notice of proposed rulemaking. It's very typical, not just at U.S. Citizenship and Immigration Services, but really throughout the federal government, that when you have a reason to start a regulation, it becomes sort of a potpourri of a bunch of things. So there may be a couple of headline items in that regulation, but it also becomes an opportunity to codify a number of policy issues that had previously simply been policies rather than actually formally regulations. We're going to talk about some administration initiatives that will have a potentially meaningful interplay with this regulation, particularly the issuance of an executive order by President Biden just in the last few weeks, really promoting or looking to promote or appear to promote the adoption of AI as a cornerstone of U.S. industry. And then we're going to get back to the big picture and talk about how the many of you on this call today can make your voices heard, how you can join with others to make your voices heard, so that the final look of this rule, once it does become a final rule, is something that really promotes prosperity, promotes success for U.S. industry, and really does, as to borrow our title, really does further opportunity. So how did we get here? What is the landscape that got us here? Let's go to the next slide. So it's going to talk about the where and the why. Where are we and where are we trying to go? I think the first place to understand, and that's something that drives, I think, a lot of these mega regulations, and you know, this happens across administrations of different parties, is that Congress has basically been gridlocked on immigration matters for a very long time. You know, whenever people ask me about H-1B bills, one of my favorite things to say to them is if you went into the Senate or the House of Representatives website and Googled H-1B, within those websites, you would find that pretty much every week, some member of Congress somewhere submits a bill in committee related to some aspect of the H-1B program. Notwithstanding, we have not actually had any meaningful legislation on H-1Bs for a very, very long time. And it is caught in the buzzsaw. This issue is caught in the buzzsaw of what really is congressional gridlock on a number of immigration issues. And I think it's a good point to invite Randy in. He's somebody who really has been in Congress, around Congress, talking to Congress for a longer time than it might appear. And so, Randy, am I being fair? Am I being fair here?
Well, I did not have gray hair when I started lobbying Congress on immigration reform, so I think you're being fair. You know, the reality of it, Leon, it's interesting, and my time probably goes back to Hagel-Daschle 2001, but a lot of the sound and fury on the Hill, of course, now it's around border security and asylum, but in this context, was really in the lesser skilled programs and trying to expand employer use of creating a new program for lesser skilled workers. And that's where my negotiations were under S744 with AFL-CIO. And we eventually got a bill done, although it never got through the House. But my broader point here is the H-1B stuff. I mean, you guys live and breathe it, but really it gets lost in the shuffle. And I think it's important to remind people listening today that the union opposition to these worker programs has not been limited to the lesser skilled. It's very visceral and hard on even the H-1B program, which gone are the days when we had a bill we could lift the cap to 198,000 back in the early 2000s. And I think I'm not going to take a lot of time, but let me read a statement from the AFL Executive Council Under current law, employers, especially in high tech, are abusing temporary visa programs to allow hundreds of thousands of guest worker programs with no rights and no job security to take opportunities in the United States. There are now more than 1 million of these workers in the United States under the two largest guest worker programs, H-1B and L-1. Yet neither of these programs connects in any way to the realities of the U.S. labor market. Rich Trumka on Capitol Hill, specifically talking about H-1Bs in the context of a non-high-tech company, who I won't name, noted that the H-1B program, quote, allows employers to stifle wages, create a captive workforce, and make previously full-time jobs insecure and temporary. And you could go on the Communication Workers of America website and pull down various similar criticisms of the H-1B program. I raise it here, Leon, to note that, one, I don't think a lot of people sort of see this degree of opposition in the union movement because they're focused on other worker programs like H-2B. But I think I see the hand of the unions and how this new proposal has been written, which I know you're going to get into. And considering the president has said he's the most pro-union president since I think Julius Caesar, it's not surprising for me to see this kind of role, perhaps behind the scenes, and how the proposal was written. Why is that important? It's important because when you're trying to get changes, I think you need to understand, and the audience needs to understand, that this is not just about convincing DHS on specialty occupation or something. If the unions are behind this, it's going to be a tougher lift for the business community to get the kind of improvements they'd like to see, and I know you're going to be talking about.
No, I think that I mean, you mentioned something about the realities of the labor market, and I think that brings us right to the next bullet. I started as USCIS director in 2014, and there was a time not long before that where the demand for H-1Bs more or less matched the number that were available in any given year. And that demand, more or less around 2010, started to dramatically explode, and has continued to explode through the Trump years, through the current time. And that's why there were times when we were talking about H-1B caps in the realm of 200,000 a year versus this 85,000 combined that we have now. And important to recognize that in a technical way, this notice of proposed rulemaking is the sort of continuation of one that had actually been started during the Trump administration, which reached much further, in particular on some of the third-party placement issues that are in this rule. And as a result of that, ended up being enjoined in federal court before it ever became a final rule. And with the intervention of time and a number of other things that have occurred in recent years, has some other issues being addressed beyond those that were in the Trump rule. And so for that reason, you do see some flexibility now for F1 students to transition, to give them more time to transition to H-1B by having more flexibility as to their start date. It does continue to address fraud, which has been a persistent concern for USCIS. And my take on it, having been on both sides of the fence, is sure there's fraud out there, and something has to be done about it. On the other hand, it doesn't really define the overwhelming majority of what employers who use the H-1B program are trying to do. And it's also trying to tackle some of the registration fraud we did see last year. I think you're going to hear some eyebrow-raising statistics coming from either Masa or Steve in just a few moments about that. So that's sort of how we got here. These are some issues that have been sitting out there for a while. And with that, I think it's time to get into the meat of the matter. So go to the next slide. And we're going to talk about, what does it say? What does it mean? How is it going to affect you? I think, which is probably the reason most of you are on this call. We're gonna dig right into those. And with that, Steve, you are the man of the moment.
Thank you, Leon. And fortunately, I get to say something positive, about this, H-1B rulemaking proposal. So we'll kind of start there in terms of going over, the things that many employers, many people might like seeing coming out of this proposed rulemaking to modernize the H-1B program. So on the next slide, we'll kind of discuss efforts to kind of improve the H-1B CAP registration system overall. And if you are, someone that's been involved in CAP H-1B seasons, you kind of know yourself that, the number of selections that you probably got in the most recent CAP H-1B year, probably much lower than years in the past. And one of the reasons is this one, the number of registrations has ballooned. We had over 758,000 eligible CAP H-1B registrations in the most recent CAP H-1B cycle in fiscal year 2024. And, the initial selection rate, amounted to maybe about a 14% chance of selection for a CAP H-1B. And in terms of not only the numbers, but, one thing that is concerning about the registration is just that a lot of the beneficiaries who are kind of submitted, into the CAP H-1B pool can sometimes be counted, more than once. The most recent 2024 fiscal year CAP H-1B, out of that 758,000 registrations, at least 408,000 of those registrations, were for beneficiaries that were submitted more than once into the CAP H-1B lottery. So, over half of the registrations filed last year, were for individuals that were kind of submitted more than once into that CAP H-1B lottery. There's one statistic in the proposed rulemaking that USCS kind of pulled out, kind of showing, the largest number of registrations submitted for one beneficiary. This is going back to fiscal year 2023, but there was one person that was entered in 83 times for a CAP H-1B petition. So that kind of just speaks to, the one extreme of, the type of fraud that is kind of happening in the registration system to kind of, gain the numbers in the favor of a beneficiary. So what USCS plans to do about this fraud, in terms of what they can do now, they mostly have to do investigations, look into matters, and what they've been able to do is kind of issue notices of intent to revoke when they discover that a company has been, unfairly filing too many registrations on behalf of, a beneficiary if there's not a legitimate job offer. So we have seen some of that even in our office, some notices of intent to revoke H-1B petitions when that original CAP H-1B employer was found to be, kind of gaming the system and kind of not really having a true job offer for that beneficiary or kind of entering them into the lottery too many times. So, what USCS intends to do now with this proposed rulemaking is to kind of, change the way it's currently done. Right now, we submit one registration, from each company and for each beneficiary, and that registration gets counted once. So it's possible that a beneficiary right now could be counted in that lottery 4 times, 5 times, 6 times, depending on, the number of companies that submit them into the lottery. So USCS kind of wants to change that so that, that beneficiary is only counted once in the lottery. So what's going to happen is, under this proposed rulemaking, is that, there'll be one entry for each beneficiary. So that would kind of, take one big step towards trying to level the playing field so that, the odds of, the numbers should hopefully be a bit lower in terms of the total volume of, CAP H-1B registrations that we're seeing. The other thing that they're kind of, trying to do as well is make it, put some teeth to this idea that related entities should not be submitting, more than one CAP H-1B registration for the same person. Unless there's a legitimate business reason or, 2 separate job offers between, the same related entities. So that's another thing that they're trying to do as well, just to kind of, curb the amount of fraud and abuse. So hopefully, with these, attempts to kind of, improve the H-1B registration, CAP H-1B registration program, what they're trying to do perhaps is bring us to, more of those pre-registration numbers where maybe the total volume of CAP H-1B registrations might be closer to the 300,000 number as opposed to the 750,000, 800,000 numbers that we just witnessed last year. And on the next slide, I'll kind of go into.
Before we
go
go, I actually had a sort of a issue that I wanted to see if we could talk about for a second. The comment period on this rule closes on the 22nd. People are already getting ready for cap registration for this coming season. There's no guarantee, at least the way things are set up right now, that this rule will be effective soon enough to address this upcoming cap cycle. If that is what in fact happens, in other words, the rule doesn't come out until next summer or something like that. What else is out there really? And I know you talked about some revocations. Like what confidence can we have that this cap cycle will have some greater integrity than the one we just saw, where there really was a lot of bad behavior going on out there?
So I don't know, Leon, that there is anything in effect right now other than, some companies being aware of kind of recommendations from counsel. Like we have consistently advised clients to be wary of, taking on H-1Bs where an individual has noted that they have filed with multiple companies in the registration process. And this, came about quite a bit in terms of conversations last year and the year before, as we saw these numbers skyrocketing, and we knew it wasn't because the demand had increased, right? It was because some of the natural bars to entering the registration were you had to have a job offer, right? And you had to have a company that was investing in you for that job offer, and companies had to, way back when, it hasn't been that long yet, but we all remember we had to actually prepare a full petition and submit it. That was quite an expense for a company to incur. And with that, low selection rate, what we thought was low selection rate at the time, we were in the 40% range and 30% range. Now we're in the teens, and it's unfortunate, but it's because there's no real true bar to entry that is tied to the market for registration. So aside from, companies being aware of these recent, trends that we're seeing, like Steve mentioned, with an H-1B actually being revoked by the service center, where, our client was not aware, or the client was not aware that this was going to happen, was not aware that the applicant had actually had multiple registrations, right? And that this would be flagged. I think that's the natural bar right now until we see some sort of regulatory change. I actually have a question back for you, Leon. Do we see an opportunity for them to pull just this section of the regs out and issue a cap specific registration rule?
I think they're with respect to this, and I would hope also they might want to consider that also with the F1, the start date, the F1 start date issue, that those are relatively simple and uncontroversial portions of this regulation. And so I'm hoping there's a way and there's an interest on the part of USCIS in more or less unzipping this rule and taking those parts out that they can, where they can address the comments pretty quickly, pretty easily, getting those into final soon so that they're available for this upcoming cap cycle and H-1B cycle, and then dealing with the other, far weightier aspects of this regulation, and giving themselves time to properly respond to the comments that we know. I mean, they've already gotten literally, I think they're already in the thousands of comments. Giving themselves time to address the probably more substantial comments they're going to be getting on other aspects of the rule. That is one thing that I do hope to see.
And with this whole, registration proposal about, one entry for each beneficiary, one thing that they're going to try to require is having there be a passport number in order to kind of make that registration. So I know some organizations have submitted comments related to that requirement. Particularly, sometimes there might be some clients from DACA or some TPS beneficiaries that have lapsed passports that might not have a currently valid passport. So I know that's one of the comments that USCIS has received. And if you, represent someone that has dual nationalities and 2 passports, you have to make sure that if they have more than one registration submitted on their behalf, that you're using the same passport number throughout. That's going to be important if something like this does get implemented.
Makes a lot of sense. All right. Thank you for indulging my my interruption there. All right, back to you, Steve.
Okay. So I'll go over on the next slide. So this is also related to kind of somewhat to the CAP H-1B program as well. So one of the other, proposed rules is to kind of extend the current cap gap period. So, for those who know, cap gap is basically referring to, if you have employees that are currently F1 students working on OPT or STEM OPT, cap gap kind of allows them to kind of keep working up until that start date of their H-1B approval, which typically is October 1st, provided that you filed the H-1B petition prior to their, EAD card expiring. So it basically allows them to have continuous work authorization up until the start date of the H-1B petition. And for now, that cap gap benefit kind of only covers you until October 1st, in terms of when that cap gap period would kind of terminate. With this proposed rulemaking, they're kind of expanding that cap gap period beyond October 1st. And, one of the reasons for this potentially is that there, with the new registration system, there's kind of multiple rounds of selections typically. And sometimes there's a selection that's even done, even after October 1st for a second round of the CAP H-1B lottery. So even for those that get, selected in that second or third round, they too could, potentially benefit from cap gap protections that extend, well beyond the current period of October 1st. The other thing, that's kind of nice about the proposed rulemaking is that the start date for a CAP H-1B petition, previously you always had to use October 1st in order to kind of make sure that your CAP H-1B petition would get approved. They're kind of codify the flexibility where you can use a start date after October 1st of the fiscal year, but it has to be within 180 days from the date of filing based off of their proposed rule. Another thing that is kind of worthy to call out is they're kind of expanding the pool of CAP exempt H-1B employers. So we know that most organizations fall under the, CAP subject, H-1B where they have to file in the lottery. There are some CAP exempt employers, typically it's government organizations or nonprofit organizations with a research mission that might benefit from this CAP exemption that don't have to kind of, compete in the 85,000 annual lottery each year. So one thing that they're going to do is kind of expand who might qualify as a CAP exempt H-1B employer. And for nonprofit research organizations, right now to qualify, for CAP exempt H-1B status, that organization has to, have a primary mission of research. And they're going to slightly change and lower that standard so that it's a fundamental activity. So that will kind of maybe expand the number of CAP exempt H-1B, employers or organizations out there that might be able to sponsor individuals for H-1B visas. And then, in terms of implications of kind of what to think about, if there are changes, to the cap gap provision to kind of extend that period, that's something that, you're going to have to, work with your I-9 team, once that's implemented, just to kind of make sure that they are using the correct period of time, when onboarding or kind of when verifying work authorization for students who might benefit, from cap gap protection, assuming that this rule does go into effect. And then the other thing I put on here is this collaboration with research centers for CAP exempt status. There is a way for someone that doesn't necessarily work for a CAP exempt H-1B employer right now to still file an H-1B for them if the majority of their work is being done at a nonprofit research center or a government research center. They're going to lower that standard from a majority of the time to at least half of the time. So there might be some situations, probably not many, where some organizations might be able to still file a CAP exempt H-1B petition for someone if they're spending at least half the time dedicated to furthering research at a CAP exempt organization.
And just a word of caution I'll add here before we go to the next slide. Similar to how we saw kind of a mushrooming of the use of CPT, day one CPT, to kind of cover the gap for people who were running out of work authorization once they completed their studies here. They had the optional practical training, OPT, and then there's STEM OPT extensions. And then they ran out because obviously selection rates are so low. They would enroll in what we often refer to in here in this field as day one CPT. There are legitimate programs out there that have been there for a really long time and are great and can definitely be used and are successful. And then there's ones that kind of popped up as a result of a need that was deemed there in the market. We're already seeing signs of that in this space as well. So, it's just a word of caution, do your homework, make sure the individual is doing their homework. If some organization has just popped up in the last 12 to 18 months, then maybe dig a little bit deeper before agreeing, because just like with the CPT programs that came under investigation and just like the CPT programs where status is being questioned, this could also kind of have a waterfall effect where it'll have the same impact. And for you as a business, if you're sponsoring that H-1B using this cap exempt kind of exemption that's available, it could mean disruption, immediate disruption, just like, with a revocation and a denial. So just, be wary of those as well. Next slide. So if you haven't noticed the trend, we're going from like the positive and slowly moving on to kind of what else is going on that's maybe good. Maybe we're questioning, and then into more of the challenging areas of the regulations. But this continues kind of the trend of what we see that is helpful in the existing way that the regulations are written. One of them is, this concept of whether or not you have to have one degree that qualifies you for a position to be deemed to meet the H-1B criteria, versus what in reality, in real life, it's a multitude of degrees that could qualify someone for a position. And so depending on the administration, depending on the political climate, we see, kind of spikes in RFE trends. And under the prior administration in particular, these types of challenges were very frequent, right? If you listed more than one degree major, they questioned whether or not this was really a specialty occupation, if people in multiple majors and specialties could actually qualify for the role. So this regulation is helpful in that it kind of cuts that off, right? It's no longer that you have to show that it's just one particular degree that would qualify someone, but there's a range of degrees that kind of fall under an umbrella that could qualify someone. The other really great one that we saw in the regulations is this attempt to clarify the definition of normally, which many adjudicators seem to believe that it meant always, right? So if they saw that sometimes in some job postings it wasn't required, or sometimes some of your folks didn't have degrees but most did, it wasn't good enough. You had to show that it was always required. So the regulations clarify that for us to our benefit, making it more realistic, right? So normally doesn't mean always. It doesn't mean always when you look in Webster's dictionary. So it's really helping the adjudicators understand that normally equals usual, typical, common, or routine. So that's been a really a great bright spot there in the regulations. What does this mean for your H-1Bs? Hopefully no more RFEs that are specific to these particular points of the H-1B criteria. But it also means that, we're always concerned about what are you posting when you're recruiting? Do you list a multitude of degrees? And we've seen RFEs where officers will reference that they looked it up, right? They're willing to do the research there and Google it, whereas they're not in other areas. So those types of things hopefully will not come up thanks to these kind of attempts and updates to the regulations in that sense. Some of the other changes, just kind of a little bit more granular, that do mean something, include changing references from the position to the occupation, which again expands this to be more realistic again. So it's not specific to that one particular position that you are sponsoring or that you have at your company, or the specific type of position within the industry, but it's really an occupation, right? It's an occupational category that's broader. So you can show that across multiple positions within an occupation category, this is the standard, whether it's the standard type of degrees, the standard type of specialties that are involved. So that's actually really helpful, making it more realistic in real life rather than this, kind of construction of what a position on a specialty occupation is. The other thing that they've done again is again a little bit more technical, but they've combined a couple of prongs where we had to respond or validate that we meet all the criteria. There was a separation of specialized, complex, and then unique, specialized and unique. So they've kind of combined that into one. All that means it makes it a little bit easier to kind of touch and validate that you meet all the prongs of the regulations. So there have been a few bright spots there. But if we go on to the next slide, here it's a question mark whether it's a bright spot or not. Those of us who've been doing this long enough remember the days before when we weren't constantly having to file updates to our H-1Bs when someone changed work sites and went outside of the metropolitan area or the commuting distance. And we had this shift that really impacted how you monitored your H's, how often you had to update them. And I'm going to pass it on to Leon because Leon is intimately aware of this particular part of the regulation. I think you're on mute, Leon. Nope. Leon, you're on mute.
One of my earliest contacts with Randy came about over this issue. So an internal tribunal of USCIS back in, I think it was about 2015, issued a ruling that if you change the work location of an H-1B beneficiary, then that was the kind of material change that necessitated the filing of a new I-129 for that employee. That was, as Masa said, a significant change for employers. There was a lot of advocacy to get us to delay the effectiveness of that ruling, which we were able to do substantially. But it did then become a fact of life for a lot of employers going forward, and something for which I've been apologizing for the last 6.5+ years that I've been in private practice. And I actually had been hoping that perhaps this rule would present a way to soften the impact of that ruling, but it does that, but only really by restoring the deference policy. I don't see that it does it in any other way. Randy, I don't know if you have any other observations you want to make about that episode.
Yeah, never throw away your files because the issues keep coming back.
Yep. So, but that's where we are now, Masa.
Yeah, and so what this means is it's codified if this regulation passes as it is, right? If it finalizes as it is. So for those of you who've been following the SEMIO standard, because you do have H-1B employees who you do move around or who do move in, and we saw obviously an uptick of this in particular during COVID, where people had a lot more flexibility in where they were working from, and even though they were started out working from home within commuting distance, eventually they decided to move from LA to New York for a couple of months or a year or so. So that all, really became front and center, even if you weren't an H-1B employer who typically needed to address these types of moves that required new H-1Bs. But that's being codified as it stands if this passes the way, or if this is finalized the way it is set up. The other positive component is that, the deference to prior approvals is again added to the regulations and being codified. And that's really great because we saw a shift under the last administration where there was no deference. The current administration kind of brought that back, which was obviously helpful for the business because, it's important to have that expectation of continuity, right? So that you can depend on it and not each time wonder, are we going to go back to the beginning and potentially lose this person who's now become critical to us? The other thing that we've noticed in the regulations, which isn't so great, is that it also expressly empowers USCIS officers to ensure that the underlying labor condition application, your LCA that was certified by the Department of Labor, corresponds with the H-1B petition, and how they would do that. It's an open question mark. I think It's not just about RFEs and them digging into it deeper when they're reviewing, but it's actually could be on-site visits, increase in on-site visits by USCIS. So we know we already have those through their FDNS, their fraud unit, that, you know, for L1s and Hs and other visa categories that there are on-site visits. Maybe there'll be an increase. So one of the other things to just kind of be mindful, again, if this continues as it is, with the language not changing with respect to this factor, ensuring that your people at the front desk know what that means when someone comes you know, to your offices, ensuring that they know who to call, who is their point of contact. Your front desk people, your receptionists, they're probably not going to have any idea what this person is talking about. So any other, you know, guidance or one-sheeters you have for your receptionist on, if, you know, this type of person shows up, this is what you do, this should be incorporated as part of that, similar to, hopefully, if you don't already have it, or you should have, is something related to if someone, an agent comes in for an I-9 inspection, for example. So similarly, you'd want to make sure that you have protocols in place and people who know what to do if there is an on-site visit, because we know people get really flustered, obviously, and frantic. And it's not that it's a big deal, but it's, you know, you want to make sure if people are educated or have the tools, then it's easier to address those on-site visits as well. All right, going on to the next slide. So as we progress down kind of from the good, the bad, and the ugly, I think we're at the ugly in part. So Steve, you want to talk to us a little bit about this redefinition of specialty occupation?
Of course. So yeah, a specialty occupation, you know, they're going to add, they're proposing to add a sentence to the definition of what is a specialty occupation. And in particular, they're kind of calling out what they call generalized degrees. So they would say that, you know, a liberal arts degree or a business administration degree is not sufficient for an H-1B specialty occupation. So what that would mean is that if a company, you know, typically has business administration as an acceptable field of study for a position, you know, without calling out any particular sub-concentration or specialization, there's a risk that, you know, USCIS could say, well, that you know, because you require a degree in business administration, it can't be a specialty occupation because it's just a generic degree. So that's one big red flag that we see, especially for clients in finance consulting that tend to hire people out of MBA programs. You know, a big concern is, you know, them, you know, insisting that, you know, business administration does not, you know, support employment in an H-1B occupation by itself, that there has to be some additional sub-concentration or complexity with their, you know, business administration degree, with them having some type of analytics concentration or marketing concentration in order for them to, you know, show that a position could qualify for an H-1B. And, you know, in terms of, you know, the industries are going to be mostly impacted. As I said, it's mostly going to be in the world of consulting. We certainly see a lot of people in finance that still require business administration degrees for positions. So that's going to be something that, you know, if this makes its way through, companies are going to have to consider whether they keep listing business administration as an acceptable field of study, you know, for the position, you know, on their job descriptions. You know, if challenged on requests for evidence and have to show that, you know, they require a degree in specific specialty under the standard, it's going to be a red flag, you know, if it just says business administration, you know, and USCIS could, under this proposed rulemaking, take the position that it technically won't qualify, you know, for a specialty occupation.
Yeah, and so, I mean, for context, I'm just going to read what the current regulations, you know, this broader text in the regulations of, you know, an H-1B qualifying as a specialized, a position qualifying as a specialized knowledge role for an H-1B is one where it involves a body of highly specialized knowledge in fields of human endeavor, including but not limited to architecture, engineering, mathematics, physical sciences, social sciences, medicine, health, education, business specialties, accounting, law, technology, and the arts, which is real world, right? Any of these positions, anyone in any of these fields, you're not going to be able to go into it with your high school degree, right? You're spending time getting your bachelor's, your master's, potentially your PhD, whatever the case might be. But any one of these, if you're a professional in that field, is by its definition a specialty occupation. In the way that these regulations are now kind of highlighting the fact that a general engineering degree, a general physics degree, and that concept is an odd one if you think about it in real world practice. How is physics general? By definition, it's not. I cannot imagine. I didn't do very well in physics in college, so I can only imagine, right, what it means. Leon, I'd love to kind of hear your thoughts on that as well. This concept of general versus kind of specialty, the way that they're defining it.
I think it's either a word that doesn't work in this context, or that is being misapplied. And I'm concerned here not only about the language of the regulation itself, but a lot of what we saw in the preamble to the notice of proposed rulemaking, which in turn will probably turn into training and implementation directions to USCIS adjudications officers, declaring, for example, that business administration, which I know you like here, that's a general degree. It may be a broad degree, it may be a degree with broad application, but that doesn't mean that it, in fact, it has the complexity, the depth that you would ordinarily think of as being part of a specialized degree. So having, general be sort of the opposite of specialized doesn't necessarily work in a way that really reflects the content, the expected content of some of the degrees that, at least in the way the preamble is written, are being declared as general and therefore not specialized. And so that's certainly one area where I know we're going to be seeing lots of comments to the proposed rulemaking from a lot of quarters.
Yeah, and the other part I see of great concern in real world, whether you have an engineering degree or a life sciences degree, this concept of being involved in technology, it's all interrelated now. You really almost can't have one without the other. So one of their examples, notes if an individual could qualify for a petitioner software developer position based on having a seemingly unrelated engineering degree, then it cannot be concluded that the position requires the application of a body of highly specialized knowledge. Well, there's so many companies out there who are very clearly going to disagree with this and be able to document that they have folks who are developing software, developing applications, but it's not because they're not able to do it because they have a computer science degree, or right, they're able to do it because they have the underlying degree that is actually really critical to the development of whatever the technology is. So that's concerning because it really just misses realities of organizations and industries across areas where this world of technology and your hard sciences, your life sciences, your quantitative, like they all merge. I don't think you can have one without the other. And in this day and age, it's surprising that they're kind of missing the point on that. So, and with that, we'll go to the next slide. So one of the other components of this relates to this idea of nexus as well, which, we've all seen quite a bit. And, Steve, can you talk to us a little bit about this concept of nexus and relatedness?
Of course, yeah. And, currently, the H-1B criteria, it's just, a bachelor's degree is normally required for entry into a position, and now it's going to be occupation if the proposal goes through. What they're trying to add is language that kind of connects the bachelor's degree to a particular field of study being a requirement for an H-1B. So it's no longer just a bachelor's degree is normal for entry. It's a bachelor's in a directly related specific specialty in the field that is normally required for entry into that occupation. So we see this a lot in requests for evidence where they are kind of demanding a direct nexus and connection between the position and also the field of study that's acceptable for the position. But this is kind of the first time they're actually kind of adding this language kind of directly to the criteria for what is an H-1B specialty occupation, or proposing to add this, to it. And what it does is it takes away your ability to, if someone does have a background that maybe where you emphasize more of the coursework or not so much the name of the degree itself, to qualify for the H-1B, this could potentially put that, at risk in terms of being able to kind of, get an H-1B for someone, if the name of the degree doesn't necessarily align so much with the expectation for the position. And then, did you have anything, Masa, you wanted to add for this?
Yeah, so the other component of the definitions that we wanted to highlight is this kind of third-party placement language they have added in there in terms of for those H-1B petitioners who place their folks at an end client. So if they're staffing their end client, or supplementing the staffing, that ultimately it's the end client's requirements that would be controlling, not the staffing company's requirements. So one of the highlights here is a lot of the H-1B criteria and issues that we deal with sometimes have an interplay with labor and employment beyond just the context of immigration. So for me, this kind of stood out as well. Could it be another flag for a potential joint employer allegation as well? So just kind of things to watch out for when looking at this.
Yeah. On that point, Masa, that's the joint employer is top of the list for organized labor in terms of expanding the concept, whether it's under the FLSA, and there's a rulemaking going on right now at the National Labor Relations Board that's being challenged. I mean, this is very close to the top of the list, and it's interesting to see it here, and I wouldn't ignore it because some criteria might pass, may not be that big of a deal here, but then it'll be carried over under some other regulation and some other statute, and someone will say, oh, well, we did that in the H-1B rule. What's the big deal? No one complained about it. So I think it's definitely good you red flagged it.
Yeah, so that in combination with just, again, anticipated increase in site visits in this respect as well. So, being aware of, well, do you have folks on your premises that are not your H-1B folks, but that have been placed and you're the end client, because you also have to be prepared for those site visits that may be coming from those petitioners. So we've kind of given you what does it look like, where did it come from, and we're going to pass it on to really Steve and Randy to talk through and spend some time with us on the implications, the politics of it. What can we do? What are our options? Because this is still just a proposed rule. There is an executive order on artificial intelligence that actually incorporated call outs to immigration and using immigration to support the efforts of the U.S. economy and U.S. employers. Next slide. And, just questioning whether or not the current version of these H-1B modernization rules are actually in line with that executive order and the expectations and the goals of that order and of this administration and of businesses ultimately. So something to watch out for, but I really think this is key to highlight as we look at these proposed regulations, as comments go in and as we have conversations. So I'll pass it on to you, Leon, to talk through some of those options we have to advocate.
Yep, thank you. And before I do that, I'm just going to quickly read the CLE code. That's S as in Seyfarth, S as in Shaw 7734. Again, SS 7734. So, when we're talking about regulations, they are being written by, presumably, written by an executive branch agency that has specific expertise and specific authority in the area that is the subject of the regulations. And the interplay about how a decision is made to actually issue a regulation, because you don't always have to issue a regulation. Sometimes Congress tells you have to, and that's one thing, but then other times you're doing it because there is some political or policy motivator for issuing that regulation. And then the shape of that regulation, once you've made a decision to write one, is determined by forces that are not always visible. So on the one hand, you have clear political drivers. So Randy was talking about the influence of unions, their particular political agendas, who they're trying to help, and that's one thing that's visible. But at the same time, you have stakeholders within the business community, who are making their voices heard, who administrations, whether Democratic or Republican, certainly don't want to have unnecessary fights with the business community. But then you also have the actual agency itself. It has its own views. It has its own exigencies that drive the shape of its own biases that drive the shape of a rule. Among other things, they see this stuff every single day. They're the ones who have the responsibility for living with whatever this rule becomes. At the same time, they have particular views on these things that come from the experience of doing what they do that may not always be exactly in line with what the unions are thinking, the business community is thinking, the White House is thinking. And so there are always all these undercurrents when these rules are being written that drive what they're going to look like. And so here we have some elements that seem a bit out of line, certainly in terms of our experience as immigration lawyers, in terms of what we're hearing from our clients, that are actually a bit out of line with the reality of what businesses are experiencing. And so one of the questions, I guess, Randy, is what do we do about it now? There's notice of proposed rulemaking. We're going to comment on it. What are the various levers that are out there to affect this process?
Yeah, Leon, and this was a traditional reg coming out of the Department of Labor under this administration. You know, I'd almost say some of these traditional levers I'm going to talk about, you know, are checking the box, but they're probably a waste of time because DOL has got its agenda, and the career people are gonna do it, and they have to support at the highest parts of the White House and certainly within the Department of Labor. But I think this is different. I think that we have this union issue I've mentioned, but I think that probably the people at the higher ends of the administration aren't aware of what this rule does in a lot of ways. And I'm not casting aspersions on the DHS bureaucracy, but you know, things have been put in there and then they move on to the next job. And I think here in this case, it's very important to try and make sure other people in the administration hear about your legitimate issues. And you know, one of the traditional areas, of course, is this is an NPRM, but the business community, you guys, I think, would want to ask for a meeting with OMB, you know, under Executive Order 19094, which is the successor to when I was doing these, Executive Order 12291 way back when. But this clearly falls within the scope of the executive order and OMB review. I checked that. But the point is OMB's job is to, one, reflect the views of the president, but also to coordinate policy between the agencies. And Masha, to your point on the executive order, you know, there's parts of the executive order, as you point, I mean, the big executive order that seem contrary to this, like facilitating visa approval and all that. And OMB needs that to be pointed out to them by people like you. It may or may not be pointed out to them by Mayorkas. I doubt it. So it's your job to kind of get over to OMB and make these arguments. And again, whereas it was a traditional overtime or minimum wage, you know, sometimes you feel you're wasting your time. But I think this case would be very important for Seyfarth to lead a group of companies over to OMB under the executive order and talk about, you know, the real world implications of some of the adverse parts of this NPRM and why would it have an adverse effect on your operations in a way that's inconsistent with the president's own executive order. And they won't respond because they never do respond. That's their modus operandi. But I can tell you, depending on who's in the room, but they do listen. And if you've got some points, you know, they'll take that back to their higher ups and hopefully they'll report up the chain. OMB is an extension of the presidency in the White House. This is also an opportunity to raise concerns under the Paperwork Reduction Act if certain arguments make themselves known. I know the reg estimates an increase of $70 million in paperwork issues. OMB has exclusive jurisdiction under the Paperwork Reduction Act. they enforce the law, and at least under Republicans, they took it quite seriously. So there's a couple of prongs here to be made, in addition to your traditional submit comments to the NPRM. And again, I think in this case, it would be much more valuable and much more useful than a traditional sort of labor reg coming out of DOL, because the politics are just different, and I think the substance is different. So that's something I would now. Those meetings are on the they're not public, but there is a OMB website in which it will disclose who attends. So I've done many of these. Companies always fear some kind of blowback. I frankly have never seen a situation where a company got a blowback for participating in something like this. And there's always a little bit of risk, but it's important to get in there for a company, and you guys lay out the generalities, and companies bring up anecdotal stories to talk about, how this would really work in the real world. And as great as Seyfarth is, you really need some backup like that behind you. Hopefully, a couple of big companies and a couple of smaller ones. And there's certain companies you wouldn't want in the room, but we could have an offline discussion.
I think that's
none that are on this webinar.
Yeah,
Okay.
I think that's a really important call out. And I've mentioned this in our conversations as we were preparing. I think the narrative out there is very focused on IT software developers, but it's a broader spectrum of organizations that are impacted and areas that are impacted with emerging technologies. It's not software developers. So there's more to it than that. And I think the narrative needs to change.
Yep. So we are just over the top of the hour. A couple of things I would add is, there are many different ways that companies can either comment directly or comment through industry organizations like the U.S. Chamber of Commerce, Society for Human Resource Management, a number of other organizations that you can expect will be submitting comments and want to hear from you. So I did want to point that out. And with that, I want to thank everybody for their attendance. A number of you were kind enough to share questions. We are going to prepare answers to those and then circulate those to all our participants today. With that, I wish everybody a good afternoon wherever you are.